If you're going to take a case to trial, or if you're going to take a case that's going to last a year or two, you have got to understand the kind of emotional impact that's going to have on a client. It just isn't all about the cost of litigation. If you don't, you're missing a big part of being a good lawyer.
It's very easy as a litigator to spend a lot of time and a lot of money, but that's not in the client's best interest. The clients need efficiency and effectiveness.
They're not afraid to really roll their sleeves up and get involved. In that respect, they lead the case versus ask the client to lead the case. There's a big difference there. I don't have time to deal with this, and so I rely on the team at Graydon to do this for me, and the results speak for themselves.
When you get involved in litigation, whether it lasts 6 months or 3 years, it's one of those things in life you never forget.
We had a relationship with a branch of the Canadian government related to the electron beam business. They decided to exit. That would have left our company holding the bag, and it's a multi-million-dollar bag. And we had no choice but to sue.
For the closely held business, for a family business, there are times when they run into matters that the critical issue is a bet the company type case.
Having that responsibility on our shoulders is something that we pride ourselves in, because we know that this particular piece of litigation is dramatically important for them.
Within a couple weeks of us delivering our first car, all of a sudden we get papers in the mail. The papers I was worried about getting. I've never been in trouble in my life, so I'm thinking, what do I do now? Mike came to me and assured me, he says, Joe, your job is to take care of your company. You go home, you sleep at night. You don't worry about anything. I got this. He was all in.
If I get sued in a case, or if I have to sue someone, I'd want my lawyers to really take a good hard look at what do I do, what matters to me. You know, in some cases, you do have to take it all the way to trial, either to prove a point or because you have no other options. But in some cases, the best course of action is to settle quickly. For us, we've got attorneys who I would not mind putting up against any of the biggest firms in the region, even in the nation, and we've done it before.
We're going to try to get them to their end result in the least painful, most efficient, most cost-effective way. And sometimes that's saying, you don't want to go full bore here.
Graydon Head's team was very talented litigators. What do? They litigate. We were on that battlefield, and he recommended it was time to attempt to settle. And that was the right thing to do.
I don't know who invented the billable hour, and I don't think it's a concept that should survive very much longer.
Graydon has made a substantial investment in data analytics, so we can track past matters that we have that are similar to cases that we are taking in, where we can more accurately predict what our costs are going to be. That allows us to have a conversation with the client. Would it be best to have a flat fee? Would it be best to have a contingency fee?
For us, we consider them a core advisor and somebody who, a firm that goes beyond just legal representation, but really helps us build our business.
You know, it's clients coming back who truly are enjoying the relationships that's been built through some really tough times, through some really hard litigated cases. But you know, we've built great relationships throughout, and that's part of what makes being a litigator fun.
When you know that you have helped them to walk through something, so they're not on their own and they're not feeling like they're on their own, that's the best feeling for us.
There really isn't a case that we can't handle, and I think we do it well.
Can't tell you what it's like to have Mike and Graydon in our corner. And of course, yes, we won.